Governance expert Dr. Sam Koma joins me now. Dr. Koma, good morning to you and welcome. On the big three, or the three big R's that were being tested in court today, recusal, remission and representation, it would seem that this has been a blow on all of those 3 points for the MK party. Unanimous decision for the non-recusal of all of those judges, and the legal teams failed to prove why these particular judges would not bring an impartial mind to the table. On the remission of sentence, that was also cleared up. The effect of remission is that it doesn't alter the sentence imposed by a court. And then the final blow, which is on the representation, that the former president, ineligible to be a member of or to stand for election to the National Assembly for a period of 5 years following the conclusion, in spirit, I suppose, of the full 15 months because of the issue around the remission. Would that be an apt and encapsulated understanding of the biggest pieces of what we heard in court today? Good morning and welcome.
Yes, morning, Iman, you're quite right. That's the summation we got from the judgment which was handed down by the Constitutional Court today, regarding the matter which was brought by the Electoral Commission, of course, through application of direct access, appealing the ruling made by the Electoral Court. So the good thing is that now the matter has been decided by the Apex Court. There is finality around the interpretation of Section 47, 1E, which refers to disqualification. And it is also good coming out of the judgment that we now know that the Electoral Commission is empowered by the Electoral Act, which is the law that governs the operations of the Electoral Commission, to make a determination on the qualification of candidates before an election, more so because the Electoral Commission handles the party lists from the different parties that have been registered to contest national and provincial elections, and also looking at their qualification, of course, informed by the provisions of the Constitution. So that matter has been rested. We now know that going forward, the Electoral Commission will handle the qualification part. But also, you are quite right. This is what the implications of the judgment says. It says, a remission does not alter a sentence imposed by a court of law. And in this instance, the ConCourt says the 15 months sentence without an option of a fine imposed against Mr. Zuma remains intact and remains unchanged, despite the remission which was processed by the president of the country.
I think someone needs to do the sums on the background, Dr. Koma, to measure, the expiration of that 15 months, so that if Mr. Zuma finds himself in this position or wanting to play that role and contesting for a position as an MP, from what timeline he would then become eligible to do so. But I want to go to this issue around the right, let's call it that, or the responsibility for the IEC to exercise its role in terms of 41E. It kind of placed them in a really tenuous position when these matters were being debated in the Electoral Court and now reaching the Apex Court. What's your sense on how much this win, because we're calling it a win for the IEC, is in this context of being taken to court over various issues?
Yes, the beauty about our constitutional order is that it provides for avenues, especially in terms of settling legal disputes. So you can see that initially the Electoral Commission made a determination on this matter, but then Mr. Zuma took up the matter through the Electoral Court. The Electoral Court ruled in favor of Mr. Zuma, but then we know that since Section 47(1)(e), it's a constitutional matter in the sense that it requires the Constitutional Court to make the interpretation and also arrive at a determination. So it's good that all these avenues were explored by the different parties, and we now know that the matter has now been determined by the Apex Court. It brings certainty, but also it's important to mention that the ConCourt, through the judgment, it says this issue of disqualification, it's about ensuring that there is integrity and rule of law in respect to those candidates that are nominated to stand for public office.
Yeah, very, very important talk. And that was what she covered then in the merits of their judgment delivered by Justice Tehran. I want to go to the claims of bias and the questions raised around Commissioner Janet Love. And in that respect, the context in which Love spoke was ambiguous and without specificity is what the court has determined. And this was another opportunity that was being used in court to create this kind of corrosive effect on the integrity of the IEC and prejudging former President Jacob Zuma's eligibility. How important was this for the IEC?
Yes, this one I knew that it was going to be difficult to prove. Because remember, you have to prove this biasness on the part of Commissioner Janet Love. And it's good that the ConCourt, through the judgment, they're saying what she articulated was ambiguous and also there were no specifics. So it's like giving a generalized comment on implication of, for example, Section 47(1)(e) in respect to any candidate that is eligible to stand for public office. But they're saying the parties that raised this matter, in this instance, the legal team of Mr. Zuma, could not provide tangible, concrete evidence before the court to arrive at a determination that, yes, she was supposed to recuse herself due to this apprehension of bias or conflict of interest on the part of Commissioner Janet Love.
And then it was such an interesting moment. I'd love to go back and listen to this judgment, and it was, I think, elegantly delivered in around half an hour or so. But a number of issues of law and certainty and interpretation were given, especially when it comes to a variety of things. No difference between the criminal and civil convictions, as a criminal offence has been committed. So that's now out of the way. So there's a lot of housekeeping that was done there. Before I get to the final point on granting former President Jacob Zuma or this application the opportunity for an appeal to the same court. These moments where the Constitution is being tested, and we've just celebrated the anniversary of the Constitution itself. We've spoken to some of the people who actually authored our Constitution. That it is a document that lives, it is a document that reflects the times in which it finds itself, and that it is subject to change and a constant reappraisal or reevaluation or even interpretation. From that perspective, Dr. Koma, how important is this moment in your mind?
Quite significant, but also it tells us as ordinary members of the public that the Constitution is not cast in stone, it's not absolute, it's open to different interpretations, and also it tells us that till this day, there are certain provisions of the Constitution that have not yet been tested through a court of law, especially this particular provision. Section 47(1)(e) is the first time, it's unprecedented, that the apex court had to make a determination around this particular dispute. So we need to appreciate this kind of moments, but also going forward and also looking at, is it not high time that certain sections of the Constitution be reviewed with a view to, of course, bring certain aspects as part of beefing up these provisions of the Constitution, but also the point that you raised earlier, it's a living document, and we need to acknowledge that.